In exactly 48 hours, the single most important 24-day window for H-1B hopefuls in 2026 opens, and everything you thought you knew about your chances has fundamentally changed. I need you to hear this right now, because if you're planning to enter the H-1B lottery this year, or if your employer is registering you, the rules that will determine whether your name gets selected are not the rules from last year. They're not the rules from the year before. As of February 27, 2026, USCIS implemented a weighted wage level selection system that has completely restructured how lottery winners are chosen. And if you don't understand how this affects your specific wage level in the next 48 hours, you may be entering a lottery where your mathematical odds are dramatically different than you realize. And that's not the only alert I have to share with you today. There is a $100,000 supplemental fee provision that is currently active under presidential proclamation that could apply to your case, and most applicants have no idea it even exists. Stay with me through this entire breakdown because what we're covering today could determine whether your H-1B dream moves forward or stalls before it even begins. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't deal in rumors, I don't sensationalize, I read the regulations, I analyze the policy guidance, and I translate it into information you can use. Now, before we go any further, let me be absolutely clear. I am not your attorney, and this content is for educational and informational purposes only. Every immigration case has unique circumstances, and you should always consult with a licensed immigration attorney about your specific situation before making any legal decisions. What I'm providing here is policy analysis to help you understand what's happening and why it matters. Let's get into it. USCIS has officially confirmed that the fiscal year 2027 H-1B cap registration window opens on Wednesday, March 4, 2026 at 12 noon Eastern Time. That window will remain open until Wednesday, March 19, 2026 at 12 noon Eastern Time. That gives employers and prospective H-1B beneficiaries exactly 15 days to complete electronic registration. But here's what I need you to understand. The preparation for that 15-day window needed to start weeks ago, and if you haven't begun yet, these next 48 hours are absolutely critical. The electronic registration fee remains at $10 per beneficiary for the initial registration. This is not the full H-1B petition filing fee. This is simply the registration fee to enter the lottery selection process. If you are selected, then you proceed to filing the actual H-1B petition with all associated fees and documentation. But the lottery selection itself, that's what happens first, and that's what has fundamentally changed. Now here's where this becomes critical. Prior to this year, the H-1B lottery operated on a simple random selection basis. Every registration had an equal chance of being selected. It didn't matter if you were earning $40,000 a year or $400,000 a year. One registration, one equal chance. That system is over. Effective February 27, 2026, USCIS implemented what they're calling a wage-based weighted selection system. Under this new framework, your chances of selection are directly tied to your prevailing wage level. Let me explain exactly how this works because the details matter enormously. Under the new system, beneficiaries whose positions are classified at prevailing wage level 4 receive the equivalent of 4 entries in the lottery. Level 3 positions receive 3 entries, Level 2 positions receive 2 entries, and Level 1 positions receive just 1 entry. Now mathematically, what does this mean? It means a Level 4 candidate is 4 times more likely to be selected than a Level 1 candidate. This is an intentional policy design by USCIS to prioritize what they describe as higher skilled, higher compensated specialty occupation positions. The stated rationale is that higher wage levels indicate positions that genuinely require specialty occupation qualifications and represent the kind of talent the H-1B program was designed to attract. This is what many H-1B applicants are misunderstanding. Wage levels are not simply about how much money you make. Prevailing wage levels are determined by the Department of Labor based on the specific occupation, the geographic area where the work will be performed, and the experience and qualification requirements of the specific position. A Level 1 wage represents entry-level positions for workers who have a basic understanding of the occupation. Level 2 represents qualified workers who have attained a level of expertise sufficient to perform basic duties. Level 3 represents experienced workers who have a mature grasp of the occupation and can work independently. Level 4 represents fully competent workers who have mastered the occupation and can supervise others. So your wage level designation depends not just on your salary, but on how the position itself is classified and what the prevailing wage data shows for that occupation in that location. If you're a recent graduate entering a level 1 entry position, your odds in this new lottery system are significantly lower than they were under the previous random selection method. If you're an experienced professional in a level 4 position, your odds have improved substantially. There's one detail most people are missing about this new system. The wage level determination is based on the labor condition application that will be filed with the actual H-1B petition, not on the registration itself. During registration, employers provide basic beneficiary information, but the wage level classification becomes relevant at the selection algorithm stage. USCIS will be using wage level data to weight the selection process. This means the accuracy and strategic positioning of the future LCA filing is now more important than ever. Employers need to be thoughtful about how positions are classified and what wage levels those positions genuinely require under Department of Labor guidelines. Any attempt to artificially inflate wage levels to improve lottery odds would be problematic and could create serious issues when the actual petition is adjudicated. The position description, the actual salary offered, and the prevailing wage determination all need to align authentically. But here's where this becomes even more critical, and this is the alert portion of today's breakdown that I mentioned at the beginning. There is currently an active presidential proclamation that imposes a supplemental fee of up to $100,000 on certain H-1B petitions. This applies primarily to what the proclamation defines as certain overseas hires and petitions where the beneficiary is outside the United States at the time of filing. The exact application of this fee has been subject to ongoing interpretation and implementation guidance, but I want you to understand that this fee exists, it is substantial, and it could dramatically affect the cost-benefit analysis of H-1B sponsorship for both employers and beneficiaries. If you are currently outside the United States and your employer is considering registering you for the H-1B lottery, you need to consult with Immigration Counsel immediately to understand whether this supplemental fee applies to your situation. $100,000 is not a minor administrative fee. It's a potentially prohibitive cost that changes the entire calculation for many employers, and this is separate from the standard H-1B filing fees, premium processing fees, and attorney fees that already make H-1B sponsorship expensive. Let me give you a realistic scenario to illustrate how these rules work together. Imagine a beneficiary named Priya. Priya graduated with her master's degree in computer science from a U.S. university 18 months ago. She completed her OPT, then her STEM OPT extension, and she's been working for a technology company in Austin, Texas. Her employer wants to sponsor her for H-1B status. Under the old random lottery system, Priya had the same chance as anyone else. Maybe 25 to 30% odds of selection depending on the total registration pool. But Priya is in a level 2 position. She's not entry level anymore, but she's not at the fully competent level 4 designation either. Under the new weighted system, Priya gets 2 entries while a level 4 candidate from the same company gets 4 entries. Mathematically, Priya's odds relative to higher level candidates have decreased. Now, Priya is still in the United States on valid status, so the $100,000 supplemental fee likely doesn't apply to her. But consider another beneficiary, Rahul, who is currently in India working remotely for the same company. The company wants to bring Rahul to the US on H-1B status. Not only is Rahul potentially classified at level 1 since he'd be entering a new position, but depending on the implementation of the presidential proclamation, his employer might face the additional $100,000 fee. Suddenly, sponsoring Rahul becomes a fundamentally different business decision than it was 2 years ago. This could affect you even if you're not entering the lottery this year, because these policy changes signal a broader shift in how the H-1B program is being administered. The emphasis on wage levels reflects a policy preference for higher compensated positions. The supplemental fee reflects a policy preference for beneficiaries already in the United States over those abroad. Whether you agree with these policy directions or not, understanding them allows you to plan your immigration strategy accordingly. If you're a student on F1 status considering your options, the path to H-1B status now includes this wage level calculation. If you're an employer developing your immigration sponsorship strategy, the cost-benefit analysis has fundamentally changed. So what should you do with this information? Let me give you a concrete action plan. First, if you're a beneficiary expecting to be registered for the FY 2027 lottery, confirm with your employer in the next 48 hours that they have completed all necessary preparation. Confirm they have your passport information, your educational credentials, and all details needed for electronic registration. Do not assume this is handled. Confirm it explicitly. Second, understand your likely wage level classification. Ask your employer or your immigration counsel what wage level your position will be classified at on the labor condition application. This affects your selection odds, and you deserve to know where you stand. Third, if you are currently outside the United States and considering H-1B sponsorship, have an immediate conversation with immigration counsel about whether the supplemental fee applies to your situation. This is not something you can afford to discover after the fact. Fourth, monitor USCIS announcements throughout the registration window. USCIS has been known to issue technical guidance, system updates, and clarifications during the registration period. Visit the USCIS website directly. Do not rely solely on social media for official information. Fifth, and I cannot emphasize this enough, consult with qualified immigration legal counsel. The policy landscape is complex, the stakes are high, and you need professional guidance tailored to your specific circumstances. Now let me provide broader context about where this policy sits in the immigration landscape. The weighted wage level rule was implemented through the regulatory process, which means it went through notice and comment rulemaking and has been finalized. However, this protection may not be permanent. Regulations can be challenged in court, and we've seen numerous immigration-related regulations face legal challenges in recent years. It's possible that advocacy groups or affected parties could challenge this rule, arguing that the statutory language of the H-1B program doesn't authorize wage-based weighting or that the regulatory process was flawed. As of today, no such challenge has resulted in an injunction and the rule is in effect. But if you're planning your immigration future years into the future, understand that policy landscapes shift. What's true today may be modified tomorrow. The supplemental fee provision exists under presidential proclamation authority, which means it can be modified, extended, or revoked by executive action without congressional involvement. Its long-term status depends on executive branch decisions that can change with administrations. Why does all of this matter beyond the technical details? Because your H-1B status is not just a visa category. It's the foundation of your professional life in the United States. It affects whether you can continue the career you've built. It affects whether your family can remain together in this country. It affects your ability to eventually pursue permanent residence through employment-based green card sponsorship. For many of you watching, H-1B selection or non-selection will determine the trajectory of the next decade of your life. That's why I take this analysis seriously. That's why I focus on accuracy over sensationalism. The decisions you make in the next 48 hours and the decisions your employers make will have real consequences. Being informed is the first step to making those decisions wisely. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. If you found this breakdown helpful, leave a comment below telling me your visa category and what immigration topic you need me to cover next. Share this video with anyone you know who is entering the H-1B lottery this year. They need to understand these wage level changes before the registration window opens. And if you believe in fact-based, responsible immigration coverage, hit that like button to help this video reach more people who need this information. I'll see you in the next breakdown.